The Constitutional Court has found that President Cyril Ramaphosa has the legal right to reverse the high-ranking NPA appointments made by his predecessor, Jacob Zuma, but it was not a unanimous decision. In fact, Chief Justice Raymond Zondo found the opposite, but was overruled by the majority. Let's unpack this further with Dr. Jean Redpath, who is a senior researcher for the Africa Criminal Justice Reform Program at the Dulomar Institute at the University of the Western Cape. A very good afternoon to you. Thank you so much for your time. A very, confusing matter here. One, ConCourt saying, yes, President Cyril Ramaphosa had the right to reverse Zuma's NPA appointments. And then on the other end, Chief Justice Raymond Zondo finding the opposite. How should we begin to interpret this?
Well, I think what this judgment really highlights, so the judgment turned on a very technical point, the point of whether or not the former president, President Zuma's appointment had been completed or not, whether the whole process had been completed. And so there's a lot of technical argument around that. But I think the more important point highlighted by this judgment is how crucial those positions are, the top 14 positions in the National Prosecuting Authority, the National Director, the 4 Deputy National Directors, and in each division, the Directors of Public Prosecutions. And it was 2 appointments in those divisions that were at question here, which were made literally in the last week of Zuma's presidency. Those can all be made by the president. The president alone appoints the national director. And then the other positions, it's the president after consultation with the minister and the NDPP. Now, after consultation means he only has to consult. He doesn't have to go along with the decision. So that's an enormous amount of power in a president to shape the political nature of the National Prosecuting Authority, to put it bluntly. And that is it's a key risk. And our Constitution actually provides that the legislation must ensure that these appointments and the way things are done ensures that the prosecuting authority can act without fear, favor, or prejudice. And I would argue that the situation that we currently have, where a president gets to appoint the 14 top people without consultation, without having to go through any process of the JSC or anything like that, that was done with the NDPP because our President Ramaphosa wanted to have a more inclusive process, and there was also some pressure from the Helen Suzman Foundation. But that's not in the legislation. So I would actually argue that the legislation doesn't ensure that the people who are appointed will be able to act without fear, favor, or prejudice, particularly when it comes to high corruption matters, which involve members of the executive. And so I'm wondering to what extent the court was influenced by the fact that it was Zuma who made these last-minute appointments in interpreting the technical detail of the appointments and whether or not the appointments had been completed.
So the final order is based on the majority judgment. In trying to really just understand that and perhaps also draw some comparisons around the very thin line between legal matters and political matters, what can we conclude from that?
So what we can conclude, well, what we've been seeing happening in the National Prosecuting Authority, or what we saw happen over the last 10 years, was capture of not only our police but also the prosecuting authority, where appointments were made not because people were necessarily the best person for the job and would act independently, but with a clear agenda associated with the appointments. And the court ultimately sided with a judgment that would help to clear up some of those seemingly political appointments. And so what we're seeing is the court kind of as a whole affirming the attempts that the National Prosecuting Authority have been made to remove some of the more political appointments, some of those who who've not performed or have performed in a way which brings into question whether they are acting without fear, favour or prejudice as required by the Constitution. And this is most clearly seen when serious matters are not prosecuted, and particularly where they involve senior members of government. And that is where the concern lies, and it's another step in the process of attempting to rectify the state capture era.
Yeah. Chief Justice Raymond Zondo spoke about the dissenting judgment, essentially saying that he said there were certain aspects of the factual background that the majority judgment did not cover, and because of that, in his view, they're important for the proper determination of these matters, saying, really just backing how he feels about Ramaphosa not being entitled to revoke or withdraw the applicant's appointments.
Yeah, so in Chief Justice Zondo's view, Ramaphosa's appointment had been completed in its entirety, so that the judgment turned on that point. If the appointment had been made in its entirety with all the requirements, including those read in by practice, then Ramaphosa would not be entitled to reverse it. If, on the other hand, as the majority held, that there was a step in the process that hadn't yet been taken and therefore they hadn't yet been appointed, then President Ramaphosa is entitled to revoke. So it's not really revoking the appointment because the appointment has not yet been made. So that is the technical point, and what Zondo was referring to was quite a lot of uncertainty around the facts. The evidence brought by each of the parties did not give sufficient certainty of exactly what went down when. And I think that is probably what the Chief Justice was referring to and what he was concerned about.
Thank you very much for helping us make sense of this outcome. Dr. Jean Redpath, a senior researcher at Africa Criminal Justice Reform, a program of the Dulomar Institute at the University of the Western Cape.